We have a sort of a special news update for the listeners this week because we got some breaking news the day that we record the podcast, some huge Supreme Court news. If you want to tell us what the Supreme Court just decided to do.
Yes, this is our second attempt at the news update because we had to refilm because this is bigger news than anything else that's gone on this week. And that is that the Supreme Court has accepted a new gun case. About 1 year after they handed down their decision in New York State Rifle and Pistol Association v. Bruin, which set up a new test for how to determine whether a gun law is constitutional or not. Now they're taking up a case on this question. And it's a case called United States v. Rahimi. Comes out of the Fifth Circuit. We've written a bit about this in the past, or actually quite a lot about this case in the past. A number of analysis pieces from members over on the Reload if you want to go and check those out. Today, get a membership, you can do that. But it's a pretty significant move because this is only the seventh Second Amendment case that the court has ever taken in its history, right? That's major ones, at least. And it's the third of three of those seven have come in the last 3 years. One was mooted. There was a New York case before New York State Rifle and Pistol Association that got mooted. Then there was Bruin, and now there's Rahimi. So it's going to be very significant because there's just not a lot of case law. There's not a lot of jurisprudence from the Supreme Court on the Second Amendment, what it means, what its limits are. And so here we're going to find out some more answers to those questions.
Yeah, it's definitely huge because not only because of what it says for Second Amendment jurisprudence, which is obviously critically important, but I think this case in particular makes it that much more significant because of just the sheer amount of headlines that this ruling initially generated when it was handed down. As you said, this deals with a not particularly good person who was convicted of possessing a firearm while being under a domestic violence restraining order, but he was certainly engaged in plenty of other conduct that we wouldn't want someone to be engaging in typically in society. And so the fact that this ruling came down just put so much attention and so many eyes on the Supreme Court, what they might do, what will they let this stand? So that just adds, I think, to sort of the excitement or the attention around this case.
Yeah, it certainly does. Rahimi is the least sympathetic plaintiff you could probably think of.
Yeah.
This is not a case, as we talked about in the past, that was backed by the gun rights groups. The gun rights movement was not trying to get this case to the Supreme Court, right? They're much more focused on, assault weapons bans or magazine limits or concealed carry restrictions. This is actually a public defender who was involved in this case. And it comes out of the pot of criminal cases that involve the Second Amendment or involve gun rights. And those are much more of a wild card, right? These sorts of cases are wild cards. They're not really as predictable as a lot of the other cases where you're used to seeing that talk about the Second Amendment. And so Rahimi himself, he's got a long rap sheet, or at least a long list of accusations and allegations against him, charges against him. So he was accused of committing an act of violence against his mother, the mother of his child, which is what led to the domestic violence restraining order. But he doesn't, to that point, he doesn't have any felony convictions, right? And he still doesn't to this moment, as far as I'm aware. However, the police found that he had guns in his house while under this restraining order, which under federal law makes you a prohibited person. You can't own guns, you can't buy guns, you can't possess them when you're the subject of a domestic violence restraining order, whether it's a federal one or state one. In this case, it's a state order. But the reason the cops found that he had guns was because he went on this crazy crime spree, basically. Or he's accused of going on a crazy crime spree, I should say, that involved multiple shootings. He shot at somebody that he had sold Percocet to. He shot at somebody during a road rage incident after he cut them off. He shot into the air at a Whataburger because his friend's card was declined. These are the allegations against him. And those are all obviously serious crimes as well that are very likely to result in felony convictions for him, which means he'll probably have his gun rights taken away under those provisions. But the key bit here is that while investigating those other crimes and those other allegations, the police found that he had guns in his house, even though he was subject to this order. And so the Fifth Circuit looked at this case, and it's interesting, right? Because they originally they've looked at this exact law before in the Fifth Circuit, and even very recently ruled that it comports with the Second Amendment. It's not a violation of the Second Amendment to take someone's gun rights away if they're subject to a domestic violence restraining order. But then Bruin happened, and that changed how lower courts are meant to examine gun laws and whether they're constitutional. And now the Fifth Circuit had to find historical analogs for this kind of restriction dating back to the founding era. And essentially what the panel found, this is a 3-judge panel that ruled in favor of Rahimi, was that they didn't exist, this kind of restriction for this purpose during the founding era.
Yeah. And it sort of, there's an old adage in sort of legal cases that, hard cases make bad law or bad cases make bad law, where just the facts can get a little tricky. And as you said, it's sort of this perfect storm of certainly an individual that you would think no one would want to be able to possess a gun, but under this Bruin standard, at least as it's been articulated by the Supreme Court thus far, if there's no historical analog that is, relevantly similar to the conduct he's being accused of, it sort of leaves the judges without tools to say that he can constitutionally be permitted to be disarmed, at least permanently or temporarily.
I mean, that's the whole test, right? If the Supreme Court or if the Second Amendment's text covers the conduct, in this case, owning guns, right, which it obviously does, then is there a historical tradition that justifies the modern law, right? And the Supreme Court's looking for not just like a one-off law here or there that's in the same, that's somewhat similar to the modern restriction, but like they really want a continuing tradition of it, that this was something that even doesn't have to predate the founding era, but it's stronger case if you can find through, basically English common law history, the same sort of restriction that existed back then, and then carried on through the founding, through the ratification of the Constitution and the Second Amendment, and then on from that point. So if it came later on, if there was nothing like this until the 20th century, the Supreme Court says, well, that doesn't work. That's not in line with what the meaning of the Second Amendment is. And so, the Fifth Circuit went through and tried to look at a number of different laws from the founding period that the federal government had put up as potential analogs. And, it found that there just wasn't anything that was very close to this. I mean, especially because this is a restraining order rather than a conviction that we're talking about. And it's about protecting someone from a specific threat. This is how the Fifth Circuit framed it, at least. It's about protecting someone from an individual from a specific threat from a person, or not a specific threat, but a general threat from a single person. And so it's not about disarming dangerous groups of people, necessarily people who are dangerous to society. That's what they found, that, some of these old restrictions on, some of the racist laws that we've talked about in the past, restrictions on selling guns to Native Americans or blacks or other groups that the legal theory goes were dangerous to society, and therefore there's sort of this dangerousness standard that some courts have looked at for who can be restricted. It wasn't just those groups. There was also like loyalists were included in there. You could disarm somebody for not taking a oath of loyalty to the United States after the Revolution. And so that was another idea of like, well, these people are considered to be dangerous to society as a group. And so the domestic violence restraining order is more about, according to the Fifth Circuit at least, trying to keep someone from owning guns because they are a dangerous threat to a specific individual, namely whoever took out the restraining order. And so they said that's not really the same thing. It's because it's an individual being restricted instead of a group of people. And so yeah, they also looked at things like surety laws, which were also not, they weren't similar for a number of reasons, right? Surety laws had to do with somebody putting up basically a cash amount to insure themselves if they were accused of being dangerous, so that they could carry a firearm with them. And obviously there's some similarity on the dangerousness side of the individual being accused of them being specifically dangerous, but the punishment side is different, right? Somebody in that situation would have to put up, basically a bond or it was called a surety, but it was a bunch of money to then be able to carry their guns. And so it wasn't a total ban on them owning firearms for the duration of this period of time where they're under a restraining order. So, there were a number of ways where the Fifth Circuit said these laws that have been relied on aren't actually good analogs.
Yeah. And you've seen sort of critics of the Bruin standard overall sort of glom onto that, basically that analysis and say that that's a weakness of the Bruin test. The fact that,
right,
well, this is a modern problem that we clearly as a modern society want to deal with. And if it was just silent, if the historical tradition was silent on this issue, then that's an inherent weakness in the Bruin test, is at least what they would argue. And so that's
Jake
what I think.
Charles has made that argument, the professor and former head of Duke University's Firearms Law Center.
Right.
That's been something that he's talked a lot about. But yeah, there's a lot to it, though. It's not clear exactly how the Supreme Court is going to come down on this, right?
Yeah, right. That's what I think is the interesting part, is just how do the justice, because obviously the justices, they just established this new test. Some would argue it's the Heller test, but they've articulated it explicitly, at least in Bruin, as the standard going forward. So just a year out, you can't imagine that they're going to abandon the Bruin test. So how do they re-articulate the Bruin test in this specific scenario? Do they say it's permissible? Do they find some rationale where it's permissible? Do they get maybe a little looser with the historical analogs that are allowed? Or do they simply say that, the Fifth Circuit got it right and it's just the history is what it is? I think that's going to be pretty interesting to see how they come down on that.
Yeah. And I wrote a whole analysis piece about this back in February when the Rahimi case was first decided, that looks at sort of how is the Supreme Court going to come out on this? But, it's really is something the Supreme Court had to take up, honestly, sooner than later, because as you wrote in an analysis piece too, this was beginning to cause a lot of circuit splits. Or not a lot of circuit splits, but it caused a circuit split, the prohibited persons categories, not the domestic violence restraining order one in particular, but all of the different ones that exist in federal law. You're starting to get circuits ruling different ways on them. And then at the same time, you're getting a lot of district courts going completely opposite directions on this same question as well. And so this is kind of something they had to, at some point, address because it's becoming a major issue. Now, the Supreme Court has talked a little bit about these prohibitions in federal law, right?
Yeah. In dicta and Heller and reiterated in McDonald and once again reiterated in Bruin, they've sort of said it's, they've sort of just like said it's self-evident almost, like, oh, nothing we're saying here should cast doubt on felons not being able to own guns. So that's sort of
they're not saying it's evident that like the law is constitutional. They're just, I don't know. It's kind of more of where these rulings don't explicitly implicate the felon in possession bans or the mental people banned for mental illness, right?
I guess it's fair. Lower courts have interpreted it as them saying it's self-evidently correct, which they have that's gotten them into some trouble in some rulings, as we've covered previously. So I guess that is a fair distinction. They haven't said specifically it's constitutional. They just said nothing we've said thus far has cast them into doubt.
They're kind of implying they're constitutional, or at the very least that they're not affected by Heller and McDonald. Bruin, you saw it repeated in the concurrence from Roberts, which also kind of gets to like, how is the Supreme Court going to come out on this? Because if you recall, the concurrence in Roberts, the Kavanaugh wrote the concurrence. Roberts joined the concurrence, which gives you 2. And then if you add that to the 3 liberals who are almost certainly going to vote to uphold this, maybe they won't, who knows, we'll see, but I would imagine they probably will. That gives you 5, which is all you need. Now, obviously, the Bruin concurrence doesn't deal with this question of, the restraining order, whether that's a high enough legal standard to strip someone of their constitutionally guaranteed rights. That's probably the strongest argument that Rahimi has, I would imagine. Because I don't think that the court is going to say, there were that there isn't a historical tradition of trying to keep dangerous people from owning firearms. But they might say that a restraining order process is not a strong enough process in terms of the legal protections it offers to justify taking away somebody's constitutionally guaranteed rights. It's hard to say, though, exactly where they're going to come out.
Especially, especially there's another wrinkle, the circuit split you referred to earlier, like the Range decision in the Third Circuit, and there's which struck down a nonviolent felony in possession prohibition or conviction. And then the Eighth Circuit came on the opposite side of that decision. The federal government has not yet applied for cert in those cases, but if it does, which I assume it will because it's dealing with a federal statute, could the Supreme Court take that as well and sort of deal with these issues together, sort of like you've seen with the affirmative action cases where they're relevantly similar cases, so they decided them together. And I think adding a more sympathetic plaintiff in Range, for example, it's a nonviolent felon who, his food stamp fraud is not exactly something that most people are concerned with when it comes to gun ownership.
Yeah, a couple $1,000s of food stamp fraud is not the same level as what Rahimi's accused of doing.
You could see maybe perhaps that swaying how this comes down, where they just deal with the broader question of who is covered by the Second Amendment instead of just narrowly focusing on the Rahimi case in particular.
Yeah. I mean, you could. I don't know. Maybe I wonder if they would have just relisted Rahimi if they were going to do that. It's hard to say. It's a good point. Sure. Maybe we'll have to have like a Supreme Court expert on to try and because the Supreme Court is notoriously hard to suss out exactly what
reading the tea leaves is tough.
You got to really follow the Supreme Court to understand that stuff. But either way, it'll be interesting to see where they come out and whether they try to take a broader approach to answering some of these questions or if they just go piecemeal. To me, I kind of wonder if they won't do the piecemeal thing because like they handed down the big ruling in Bruin. And now they're going to have to answer the conflicts that come up from that. But I doubt they're going to want to completely redo the test or anything along those lines. It's the same exact court, right? That just handed it down last year. So I don't think they're going to come back and be like, never mind, we're going to change this test completely again. They'll probably just give you their take on how to do the test properly in this particular circumstance, which will give some guidance. But I mean, that's really how they do it with most other cases, right? It's not, you're not necessarily getting a new First Amendment standard, test every year, right? But even though you'll get First Amendment cases all the time, Second Amendment has just not gotten a lot of attention from the court up to this point. Probably in large part because for most, until like 1934, there weren't federal gun laws, and the incorporation doctrine, where the Bill of Rights and applies to state laws as well, that didn't come until later either. So there wasn't that much opportunity for the court to talk about the Second Amendment before the federal government started passing gun laws. So, that's part of the reason why there's not as much history there. But the practical reality is that there isn't a lot of history, and they really just need to take more cases to build up a better understanding for the lower courts of exactly how this test is supposed to play out.